Trayvon Martin was a teenage boy who was fought some. He smoked marijuana. He talked about guns. And all of that should be introduced into court to prove that George Zimmerman had to shoot him. That's kind of basically what the defense was saying today, this week. And the judge said no. The defense wanted to introduce evidence that showed that Trayvon Martin was a frequent drug user, text messages, photos, that he had participated in a staged fighting, an organized fight. And this is from text messages and video. They wanted to show the infamous picture with his teeth barred and his middle fingers pointed. You can see the gold teeth. And they wanted to be able to have that entered. Now, they said, well, we wouldn't use that unless, of course, the defense was trying to paint him as a little angel who Zimmerman just slaughtered. But is it relevant at all? The fact that there doesn't seem to be any evidence that George Zimmerman knew any of that about Trayvon Martin makes it not relevant. Now, there is true that when he was talking to the police, George Zimmerman said that he thought this suspicious character was on drugs. He didn't express what he meant, what behavior indicated he was on drugs. But I do find it interesting that they're talking about marijuana and being aggressive. Now, it is true that some people can be aggressive when they're on marijuana. They become a little more paranoid, a little more nervous. There may be misunderstanding situations, like a grown man following them in the middle of the night when they're just trying to go back home from the store buying Skittles and a tea. But they didn't find the fact that Trayvon Martin, according to the autopsy, was high at the time. There was trace amounts of THC. But it is interesting that the majority of people who smoke marijuana are laid back and they're very far from aggressive. So the judge said, no, you can't have this. You can't introduce this. And the defense isn't happy, of course. But it's not relevant. George Zimmerman knew nothing of Trayvon's past. He didn't know who this was. He saw someone who he deemed to be suspicious and then acted. Now, he's neighborhood watch. He saw somebody. There had been break-ins in the neighborhood. Houses have been robbed. So it's understandable that he saw somebody and he went ahead and called the police. He didn't stick with the police. He said he was going to meet them at the mailboxes, which was significantly far away from where Trayvon's body was found. But I was interesting to hear his lawyers lay out the scenario that actually George Zimmerman did comply with the police wishes of not continuing to follow. It seems like their defense is going to be that George Zimmerman did turn around after the phone call and head back to his truck and was given a blitz attack by Martin out of ambush. Now, there's a problem with this, because if you look at the map of that neighborhood and where Trayvon Martin's body was found, and you listen to George Zimmerman's call, he says at one time that he's lost sight of Trayvon Martin. Now, that could be Trayvon sneaking and hiding to do this blitz attack, or it could be that he turned the corner between the two sets of buildings heading toward the house where he was staying, and Zimmerman would have naturally lost sight. But if he had turned back toward his vehicle, he could not have been in the area where the attack occurred. And let me be clear about something. Yes, Trayvon Martin was beating the snot out of George Zimmerman when Zimmerman pulled his gun and shot him. And if you could divorce everything that happened before the physical confrontation, you could make a case that George Zimmerman was merely defending himself. The problem is you can't divorce it. Zimmerman put himself in this situation. He was the aggressor in this. Now, should Trayvon Martin have responded the way he did? I don't know. But I do know that the stand your ground law that George Zimmerman would love to use states that if you feel your life threatened, you have the right to defend your life, even with the use of deadly force. And Trayvon Martin could use the exact same law. He was being followed by some suspicious man. He didn't know what it was about. He thought he was getting away from him, and he shows back up. So you could make the case there. The other thing that's interesting to me is that it can't be a blitz attack that Zimmerman didn't know was anything around, that he didn't know Trayvon was there. Because according to the phone call that Trayvon was on with the girlfriend, or the female, she heard Trayvon say something and Zimmerman say something to each other, yell at each other. That's not a shock. That's not a surprise. He knew that Trayvon was there. So we don't have all the facts, and it's fun to speculate now what happens. But we just need to keep it in perspective. And why are we talking about it here in South Carolina? I mean, that's a case in Florida. The only reason I want to bring it up is that how the justice, how the legal system is played out across the country is important to us here, so that we make sure our system works for the victim and not for the perpetrator, but it is fair. And the only thing I wish the judge had said was, I wish they'd made a gag order, and I would have made our speculating a little more difficult because we wouldn't have information until the jury ruled, but I think it would be better for justice. So we'll pop in and look at this case every once in a while. We're not going to make a big deal of it, but it is an interesting thing. All right, now remember, Saturday, just a couple days away, is Rides for Strides, and you still have a chance to join the team or sponsor one of us or all of us. You go to canigetawordin.com and look at the Rides for Strides tab at the top. And of course, while you're there, look at some of the other videos and podcasts we have. You know, we have our podcast every Monday evening. It gets placed on the website. So we look forward to you finding that information. In the meantime, until we talk again, get out there in the community and make a difference.